So let me begin by giving some of the relevant background and context to this legislation. So a lot of us may or may not be aware, but our NSSF was started very shortly after independence in 1965. It is 57 years old. And even though it has the fancy title National Social Security Fund, for all intents and purposes, the NSSF has just been a provident fund. A lot of people believe that they will get a pension from the NSSF, but all we get from the NSSF is a one-off bullet point lump sum. Okay, and most of you those of you who have retired and have received benefits from the NSSF, you will have seen that the quantum you get is between 60 to 80,000 shillings. The contributions to the NSSF are at 10% of pay under the Act. So even under the old Act, the contributions were at 10%, 5% by employers and 5% by employees. However, there has been a monetary ceiling on those contributions. And that ceiling has only been adjusted twice in the last 57 years. So it was 40 shillings from 1965 to 1978. It was increased to 80 shillings in 78, carried on all the way to 2001, remained 200, and when it was changed to 200. And as we, up to 2023, it has been at 200 shillings. Okay, so that is what we pay to the NSSF. And because of these, the low level of contributions, which I will talk about in a bit more detail in a few seconds, reforming the NSSF has been firmly on the national agenda for many years. Almost every government policy paper that you look at for the last more than 20 years talks about reforming the NSSF, talks about converting it from a provident fund to a pension scheme and increasing the level of contributions to it. And what gave a little bit more impetus to this was our new constitution, well, not so new anymore, that was promulgated in 2010. Article 43 of our constitution states that every Kenyan has a right to social security. This doesn't mean that the government has to give social security, but that the government should create the framework and the enabling environment for Kenyans to be able to access social security, of which old age pensions is but a part. Okay, as you will know, this act was enacted in 2013. It was signed off by the then president in December 2013, and it was to have taken effect from 2014. Its implementation was challenged in court and has been litigated since that date. But just over 3 weeks ago, on the 3rd of February, the Court of Appeal reinstated the legislation. However, as you will also have heard, an appeal has been filed by the County Pensioners Association for a review of the decision of the Supreme Court. So this is likely to be heard in the next few weeks, and we will see what the Supreme Court determines. Okay, and we'll keep you posted on that front. Okay, so now, when we look at the policy rationale, as I said, if we look at the working population in Kenya, there's about 18 million Kenyans in working age who are working in some form or the other. Those 18 million who earn a salary like you and I are only 3.1 million. So of the 18 million people, only 3 million earn a salary. So firstly, we've got more than 85% of our workforce that is excluded. And secondly, even those who are saving, the vast majority are only saving through the NSSF. So if we employer-sponsored schemes are not mandatory in Kenya. So pensions has not been compulsory. The only compulsory contribution that we've had is the NSSF. So of the more than 80,000 employees in Kenya, the number that offer retirement benefits to their staff is just around 3,000. So more than 75,000 employers do not offer retirement benefits. Their employees only participate in the NSSF as the national mandatory scheme. And the contributions to that national scheme are capped by statute, currently or previously at 200. And it doesn't take a rocket science or an actuary to say that what the NSSF will produce is going to be derisory and not meaningful. So if we take somebody contributing 200 shillings, so that's 400 shillings in a month. Multiply that by 12, you will get 4,800 or roughly 5,000 a year. And if you take a Kenyan who starts working at 25, contributes religiously for 30 years, up to age 55, if you take a 5,000 times 30, that's 150,000. Even if you hired the best managers, probably you would double or triple the money. So say 300 to 450,000 shillings. The question to be asked is that enough to send a Kenyan home in their old age? 350 to 400,000 shillings is less than what the average Kenyan makes in a year. It's a very small amount. It replaces only about 3% of your last salary compared to the desired target of 75 to 80%. So the first point is that the benefits are very low. The second point is that they're paid as a lump sum. There is a tendency for benefits that are paid as a lump sum to be not properly used, to be squandered. What experience suggests is that benefits that are paid in the form of a lump sum, they are used up within less than 3 years of retirement, and sometimes much sooner. Okay, and there is also been no safety net in the old NSSF. So what we face is a situation where most Kenyans are excluded from any form of pension coverage. Those who are saving through the NSSF are getting very poor benefits because of a structural problem in the design of the NSSF, which is contributions capped by statute. People feel that their money has been stolen or poorly applied and all the rest. But the bigger issue is that the NSSF has had a structural problem by design. So first of all, the vast majority excluded. Those who are saving, not saving enough. Employers who offer retirement benefits, only 3,000 out of 80,000 plus. There are no minimum standards on contributions, so an employer could have a scheme, but the contribution rates could be so low, the benefits so poorly designed, resulting in poor outcomes. And this is a situation that is not sustainable. We cannot have the vast majority of our people going into their old age with no financial cushion to support them during that time. Secondly, as a country, our savings rate is very low. It is only at about 10 to 11% of GDP. If we are to aspire to the levels of growth that we need to become a more prosperous nation, we need to increase the level of savings. One of the best ways of mobilizing long-term savings is through mandatory pensions. These long-term savings, if they are channeled to productive areas of investment, can help to provide the funding to develop our country, to fuel economic growth, to create those jobs that we desperately need, to develop our capital markets, to fortify our citizens against the economic shocks that they face in their day-to-day lives. So, yes, there is an initial pain, but hopefully that pain can be overcome by the long-term benefits that should flow to our economy. Okay, now having set the policy rationale, let me turn to the principal objectives of the Act, because the Act is underpinned by important policy objectives. The first of which is to improve the retirement outcomes of Kenyans, to ensure that, first of all, Kenyans have a saving, and secondly, that saving is reasonably sufficient. Okay, and this can only be done if what we save is increased. And therefore, a primary objective of the Act is to increase the level of mandatory contributions and accompany those with a corresponding increase to the level of benefits that are provided. So the benefits are wider than those that applied under the previous NSSF. They are higher, and also because of the issues with receiving benefits in the form of a lump sum, the new NSSF will provide the bulk of the benefit in the form of a regular income or pension. There is a new provident fund that is set up for voluntary membership and voluntary savings, and this is to target the informal sector in the country. Very importantly, this legislation recognizes that in Kenya, we have a thriving private industry, a private pension sector, a private insurance industry. And through the opting out or contracting out of the second tier of contributions that we'll talk about, the private sector industry is expected to remain relevant and indeed flourish. There were a lot of concerns about the old Provident Fund and whether there were any hidden liabilities there. And therefore, one of what the Act provides is that the old Provident Fund will be closed and its assets and liabilities will be fully ring-fenced, which means that there will be no mixing between the old and the new. The old assets, liabilities will remain separate to the new ones that will be built up. And finally, the Act has measures to strengthen the corporate governance of the NSSF. There are very many checks and balances that have been brought in, very many safeguards that have been brought in against wrongdoing. Okay, so let's now turn to some of the key provisions of the Act, starting with the effective date of the Act. And as I said earlier, the Court of Appeal reinstated the Act in its judgment of the 3rd of February. Now, what that means is that legally, the Act is effective immediately from that date, and therefore, statutory contributions at the higher rates are also effective from the payrolls of February, i.e. this month. There has been an appeal that has been filed at the Supreme Court. It is unclear whether any stay on the implementation will be given, and therefore it is our advice and recommendations to employers to ensure that the statutory contributions under the Act are deducted for the month of February. There is a deadline to have those paid by the 9th of March, but at least the deductions ought to happen this month. As I mentioned earlier, I have a lot of sympathy with the view that there ought to have been a grace period that should have been given to allow employers to plan, because after all, this is the middle of a financial year. Everybody has budgets, financial cycles, payroll systems that need to be adjusted, communication that needs to happen with your staff as you make more deductions, and all manner of other practical realities. And even in 2014, there was a grace period of up to May 2014 that had been given by the then CS. But let us see what happens. Okay. The Act, ladies and gentlemen, establishes two funds. So there is the old Provident Fund, which I mentioned is going to be closed and ring-fenced. We have a new pension fund that will cater for everybody in the formal sector, and a new Provident Fund that will take care of voluntary contributions for those in the informal sector. Okay. The definition of employee is very wide. So in fact, almost all of us becomes an employer under this, because even if you employ anybody, whether it's under a contract that is in writing or orally, you create a contract, and by virtue, you create an employer-employee relationship. So an employee is defined as anybody who has attained the age of 18 years and is employed under a contract of service. And as I said earlier, a contract of service can be orally or in writing, expressed or implied. Okay, there are hardly any exemptions to this. All casuals employees must also be registered. And it is recognized that because of the temporary nature of casual contracts, the contributions cannot be determined based on what the Act provides. And
Apologies, ladies and gents. We were having some connection issues, but we're addressing them now.
Very good, people. I had an IT glitch. I was thrown out of the internet for some reason. I don't know why. But I'm back again. Hopefully, we won't have another interruption. So, as I was saying, the membership of the pension fund is everybody who was a member of the old Provident Fund automatically becomes a member of the new pension fund. And anybody who is subject to the provisions of the Employment Act and above the age of 18 years and below 60 automatically becomes a member of the pension fund. Okay, the next point is the contributions under the Act. So previously, the contributions, as I said, were still a percentage of pay, but we all knew it only as 200 shillings because of the monetary ceiling. So under the new Act, contributions are expressed as a percentage of pensionable earnings. So pensionable earnings is your monthly wages, but there is an upper limit to those monthly wages, which is 4 times national average earnings. Okay, and under the Act, wages is defined as all emoluments, but excluding fluctuating emoluments. So fluctuating emoluments meaning things like bonuses, overtime, commissions, and the like. Okay, so effectively, when you look at the Act, pensionable earnings are defined as gross earnings, excluding those emoluments that are fluctuating. However, in the regulations that were issued under the Act in 2014, there appears to be a drafting regulation which wrongly defines fluctuating emoluments, which means that contributions may be based on basic salary or basic earnings for the time being, although this is still subject to clarification and legal interpretation. Okay, so I hope that is clear. The intention is for the wages to be gross earnings, excluding fluctuating earnings, but because of this drafting error, it appears that the earnings can be basic earnings for the time being. Okay, the level of contributions under the Act are at 12% of earnings in total, 6% paid by employees and 6% paid by employers. Those contributions, as I said, are subject to a ceiling of 4 times national average earnings, and this is called the upper earnings limit. And the intention under the original Act was that for the contributions to be phased in over a period of 5 years. So there is a 5-year transition period. But the effect of this is that in the next 3 to 5 years, everybody will effectively be contributing 12% of earnings. Okay. And my colleague Adil, I'll call him in a few minutes. He will take us through some scenarios and he will take us through how these contributions work in a bit more detail. Okay. These contributions are split into 2 buckets. So there is what is called the Tier 1 contributions and Tier 2 contributions. So Tier 1 contributions are contributions based on earnings up to the minimum wage, okay, which is currently about 15,000 shillings. But because of the transition, there is a lower limit that will apply for the first 3 to 4 years. Okay, the Tier 2 contributions are contributions on earnings between the minimum wage and the earnings ceiling. Okay, and Adil will run through this in a bit more detail, so you will be able to see it exactly, especially when he takes you through different salary levels. So under the Act, all Tier 1 contributions have to be paid to the NSSF. Okay. Tier 2 contributions, the default position is that they have to be paid to the NSSF unless the employer decides to opt out. If the employer decides to opt out, contracting out in the Act, then the Tier 2 contributions can be remitted to the employer's alternative scheme. For this to happen, the employer has to apply and the application has to be approved by the Retirement Benefits Authority. Okay, so just to recap, all Tier 1 contributions have to go to NSSF. Tier 2, the default is they have to go to NSSF, but you can contract out. And the bigger portion of the contributions is actually Tier 2. So the Act actually gives a substantial opt-out to people and employers. Okay, this is the phasing in of the contributions under the original act. So in the first year, the lower ceiling, the lower limit was 6,000 shillings. The upper limit was 50% of national average earnings. And you can see that it increases until in year 5, the lower earnings limit is actually the minimum wage, and the upper earnings limit is 4 times national average earnings. And as Adil will demonstrate, the contributions rapidly increase over the next 4 years. Okay. Now, what is the basis of benefits under this act? Just like in the previous act and just like the retirement schemes that many of you will operate, every member will have his or her individual account. The benefits will be based on the size of the member account. So the contributions that are paid in the tier 1, and for those who don't opt out, the tier 2, they will go to the individual account. The money will be invested. When somebody retires or exits, it is the size of the member account that will determine the benefits. And a lot of you will know that this is called a defined contribution scheme. The contributions vest immediately in the member. Interest is allocated by the trustees of the fund at least once every year. And when the trustees do that, they need to take the advice of an actuary or another qualified person. In terms of benefits, because of the higher level of contributions, the benefits, as I said earlier, will be expected to be higher. So there is a pension that is paid on retirement. This is at age 60 or at or after age 50 if somebody opts to early retire. There is also a pension paid on invalidity, a pension paid to the survivors if somebody unfortunately passes away during their working life. This benefit is paid in the form of a regular income. Okay, so only up to 1/3 of the benefit can be taken as cash. The remaining 2/3 has to be taken as a pension. Okay, and the purpose of this is to ensure that people have an adequate amount of retirement security throughout their lifetimes. Okay, there is in addition a funeral grant of 10,000 shillings. And if somebody is permanently emigrating from Kenya, they can take their entire benefit in cash. Another very important change that comes through is that all future contributions that are statutory, i.e. the tier 1 and the tier 2, have to be preserved until retirement age. See, currently we have the situation where if somebody retires, they can take 50% of their total pot. Going forward, the statutory contributions cannot be accessed until retirement age. Okay, so I hope that is reasonably clear, but if there's any questions, we'll be happy to answer in the Q&A. Let's turn now to contracting out, because this is something that we're getting a lot of questions on from employers, those who have schemes and those who don't. Okay, so as I said, the employer can opt to pay tier 2 contributions into a contracted out scheme. Okay, this application, there is an application process for contracting out. Employers need to apply. There needs to be a resolution of the employer. If they have an existing scheme, there needs to be a resolution of the board of trustees of the pension scheme. There needs to be a resolution from the administrator of the scheme. Okay, there is a form called Form C1 that needs to be completed. And if you have an existing scheme, a deed of amendment to comply with the contracting out regulations needs to be submitted. This needs to be submitted to the Retirement Benefits Authority, the regulator. The RBA reviews the application and comes back to you. They come back to you. They're required to come back to you within 30 days. Okay. Now, so as I mentioned earlier, to recap, tier 1 contributions go to NSSF. It is only the tier 2 that can be opted out of. The employer needs to make a written request of intention to opt out. And the Act provides at least 60 days before wanting to opt out. Now, this gives us a little bit of challenge because there's no grace period being given. Okay. Now, we've had conversations with the RBA, and the RBA has indicated support for expediting contracting out for those employers who wish to. And those of you who are clients, we've already started engaging with a lot of you, those who've expressed an interest in opting out. The paperwork is being prepared, and several have already gone to the regulator for opting out. If you're an employer that doesn't have a scheme, you may opt to set up your own scheme, or it might be much easier to participate in an existing umbrella fund that has a contracting out certificate from the RBA, because that makes the process for you that much simpler. Okay, for any scheme that needs to opt out, it needs to meet a test called the reference scheme test. And this is nothing complicated. It is simply that the scheme needs to demonstrate that it is registered with the RBA, it is registered with the KRA, that it is able to treat these tier 2 contributions and record them separately and properly, and that it will ensure that the benefits in respect of tier 2 contributions are paid in accordance with the Act. Okay, we've had a lot of questions that come through from people to say, if we have an existing scheme, do we need to make sure that that scheme has to comply with the Act for all the contributions? No, it is only for the statutory contributions that you have to ensure they comply with the Act. So let us say you have a provident fund currently. It doesn't mean that for your accumulated benefits or contributions above tier 2 that you have to pay those as a pension. No, those can continue to be paid as a lump sum. It is only the statutory contributions that are subject to being paid in the form of a pension and subject to preservations. Okay, and the scheme needs to comply with the investment guidelines of the RBA. Okay, and again, if there's any questions on this, the process or that reference scheme test, will be happy to respond to them. And again, the contributions need to be at a minimum what is provided for in the Act. So ideally the 6 and 6, and you can also, if you have your own scheme that does not meet the 6 and 6, or if you're looking to set up a scheme that you don't want to start off with a 6 and 6 straight away, you can do the tier 2 in terms of the phasing in over the 5 years that applies. Okay, if that's not clear, again, I'll be happy to explain. Very importantly, the Act provides that all contributions at the prescribed rates are tax exempt. The investment income on the statutory contributions are tax exempt, and the benefits when they are paid out are tax exempt. So this is actually a very generous tax treatment. The money on the way in is exempt from tax. So the contributions will be deducted before PAYE. The investment income is tax exempt, and when the benefits are paid out, they are also tax exempt. Under the current Income Tax Act, there are limits on the contributions that are tax exempt, and when the benefits are paid out, there is tax that is payable. Now, clearly, there is asymmetry. There is a gap between the Income Tax Act and the NSSF Act, and we are seeking clarifications from the government and the KRA on this difference, because the last thing we want is people to claim tax relief under the NSSF Act only to find that the KRA then comes in and slaps you with fines and penalties for not having paid tax. Okay, there are penalties and sanctions under the Act. So very important for employers to note that there is a penalty of 5% per month on delayed contributions. So contributions that are statutory need to be paid on time. Okay, and the timeline is by the 9th of the following month. There are fines on misrepresentation, there are on evasion, misrepresentation, over deductions, or for any other offense which has not been expressly provided. You can see the numbers on my screen. Okay, as I mentioned earlier, there have been measures to strengthen the corporate governance of the NSSF and ensure that the NSSF is subject to regulatory oversight. Okay, so this increase in contributions and benefits is accompanied with very tight controls. So under the new Act, the NSSF is explicitly subject to the requirements of the Retirement Benefits Act. It needs to comply with the RBA Act, and it is also subject to regulatory oversight by the RBA. The NSSF also needs to comply with the investment guidelines under the Retirement Benefits Act in terms of where they can invest in, where they cannot invest in. And there is also a requirement that the NSSF expenses be capped to within 2% of assets, and thereafter reducing to 1.5% from the 6th year of operation. And this is to control against the concern that the expenses could be high. Financial statements need to be audited and published within 6 months of the year end. There is a requirement for triennial actuarial valuations. I've already talked about the separation between the old and the new. Okay, there are regulations that have been made under the Act. So there are regulations for member contributions, mandatory registration, claims and payouts, as well as contracting out. So these have been issued. They were gazetted in 2014, and there could be new regulations made. And as and when they are made, we will notify you. There are several areas of conflict. I've already talked about the conflict between the NSSF tax exemption sections and the Income Tax Act. The definition of pensionable earnings, I've already mentioned. How does one deal with individuals who are with more than one employer? The issue of casuals. How do you deal with the probation periods? Because most pension funds admit members after 6 months, or they have to admit them within 1 year. But the Act doesn't seem to have any specified period. So again, there are several areas that we will be seeking clarifications from the NSSF as well as the RBA. Okay, now let me turn to the next part, which is to take you through the contributions and the transition here. It is said that there are 3 types of actuaries: those who can count and those who cannot. No surprises for guessing which category I belong to, and therefore I'm going to ask my colleague Adil, who's much more able than I am to do this. So I'm going to stop sharing my screen for a minute, and I ask Adil to take us through some illustrations. Adil, are you able to share your screen?
Thank you, Sandeep. As I load up, there was a question that was asked, which perhaps you can answer verbally, regarding the resolution. So the question is, you mentioned that there needs to be a resolution of the Board of Trustees, or is it the Board of the employer? I thought the trustees are managing the scheme which the sponsor is contracting out to. Please clarify the need for Board of Trustees resolution. So what I started answering was that the Board of the employer would make the decision to opt out, and then they communicate that to the Board of Trustees. So is there another resolution required by the Board of Trustees once they've been instructed? So Elijah, to your question, I hope that answers that it's both. Okay, and just give me a second as I share my screen. George, if you can hear me, if you're able to continue to answer the questions while I am presenting, that would be great. But if not, I'll try and get back to them shortly. Okay, so I've got 3 illustrations I want to walk you through. And the difference between the illustrations is the salary. Okay, so I start with somebody earning 10,000 shillings, and then we'll do somebody earning 100,000 shillings, and then we'll look at somebody earning 300,000 shillings. The reason for showing that is because I really want to illustrate a couple important things in this example. I want to show you how the upper earnings limit comes into play. So remember that the contribution is based on your pensionable earnings, which is your wages up to the upper earnings limit. So I want to show you the impact of the upper earnings limit. I also want to really emphasize that the figures for the year 1 for 2023, which you may be already familiar with, those are based on the transition rules, which Sandeep talked a little bit about. And under the transition rules, the upper earnings limit is going to be increasing very quickly. So I wanted to really hammer home those 2 points. So remember, we have some golden rules. The contribution is going to be 6% by each party. So that's the employee and the employer, 6% of your pensionable earnings. And as Sandeep has explained to us, your pensionable earnings is your wages up to the upper earnings limit. Okay, so for example, in year 1, the upper earnings limit is 18,000. So what this means is we will contribute 6% of our salaries up to 18,000, and any salary we earn above 18,000 is not subject to NSSF contributions. That's why there's a maximum contribution. So I just wanted to explain that verbally before I start looking into the numbers. So let's look at example 1. This employee earns 10,000 shillings in the month. Okay, the first thing we do is calculate their pensionable earnings. So wages is 10,000. The upper earnings limit, remember, 18,000. So that means pensionable earnings is 10,000. This member's entire wage is pensionable. 6% of 10,000 is 600 bob. So the member shall be contributing 600 under the new act, and the employer shall also contribute 600 under the new act. Okay. Now, if we want to break up the contribution into the tier 1 and the tier 2 contributions, we simply split up the pensionable earnings. Okay. So tier 1 earnings is your pensionable earnings up to the lower earnings limit. And under the transition rules, the lower earnings limit in year 1 is 6,000. So tier 1 earnings is the salary up to 6,000. So in that case, it is 6,000. And then tier 2 earnings is the pensionable earnings above 6,000. So 10,000 minus 6,000 gives us 4,000. Okay. If we calculate the two contributions, tier 1 is 360, which is 6% of 6,000. Tier 2 is 240, which is 6% of 4,000. And when you add that up, you get back to the 600. So that's simply, all we're doing there is splitting up the contribution of 600. Okay. So the employee used to contribute 200, they will now be contributing 600. Now, if we go past the transition, okay, after the transition ends, the upper earnings limit is actually defined as 4 times national average earnings. Today, national average earnings is around 40,000. So for the illustration, I have taken upper earnings limit of 4 times 40,000, which is 160,000. So look, in this example, this member earning 10,000 is contributing the same thing, even if the upper earnings limit increases, because their earnings is below the upper earnings limit. So they are already subject to 6% on the full salary. But what is changing here now in the long term is that the entire contribution becomes tier 1. Because the lower earnings limit under the Act, once the transition ends, is effectively minimum wage. So in this case, if minimum wage is around 15,000 today, the salary of 10,000 falls all under the lower earnings limit. And therefore, you can see that the contribution has become tier 1 only, okay? But it's not changed in total. It's still 6% of 10,000. So this is an example of somebody who is under the upper earnings limit today and continues to be under the upper earnings limit in the long term. Now let's go to the next example. The second example is exactly the same, except the salary is now 100,000 shillings per month. And here you'll see what the upper earnings limit is doing in its full glory. Okay, so we have salary of 100,000. Okay, we have an upper earnings limit of 18,000. That means our pensionable earnings is 18,000. It's our salary up to the upper earnings limit. 6% of 18,000 is 1,080. And this number is probably familiar to many of you because it's the maximum contribution, right? In year 1, the upper earnings limit is 18,000, and therefore the maximum contribution is 6% of 18,000. Again, we split the earnings up into the tier 1 and tier 2. So tier 1 earnings is our pensionable earnings up to the lower earnings limit, which remember is 6,000, and therefore tier 1 earnings is 6,000. Tier 2 earnings is any pensionable earnings above that amount. So 18,000 minus 6,000 gives us 12,000. Again, we can calculate 3% of each. 360 is 6% of 6,000. 720 is 6% of 12,000. And again, if you add the tier 1 and tier 2 contribution, look, you're getting back to 1080. So I hope that helps explain a little bit more and makes things a little bit more clear. So in this example, the member is going to be contributing 1,080 compared to a prior contribution of 200. So their contribution is going up by 880. And for the employer, it is exactly the same. Okay. Now, again, let's look at the rightmost column, which shows us what happens when the upper earnings limit kind of reaches its full amount over time. So again, upper earnings limit is 4 times national average earnings if there's no transition. So that would look like about 160,000 today. So you see, once the transition's gone, the pensionable earnings has jumped from 18,000 to 100,000, because if the upper earnings limit is 160,000, somebody earning 100,000 will have their entire salary become pensionable and subject to the NSSF contribution. And just to hammer home that point, I think it's very important for us to understand that after the transition is over, as that upper earnings limit increases, remember, it's defined as 4 times national average earnings, 4 times the average wage. So the important point to remember here is that for the vast majority of Kenyan workers, their entire salary is going to be falling under the upper earnings limit, and therefore their entire salary will be subject to the 6% NSSF contribution. Okay, so in this example, pensionable earnings becomes 100,000. Contribution is 6% of that, which is 6,000. Remember, I said the lower earnings limit is minimum wage, so that's around 15,000. And the tier 2 earnings, which is the pensionable earnings above the low earnings limit, is 85,000, 100 minus 15. Okay. Tier 1 contribution, 900, which is 6% of 15,000. Tier 2 contribution, 5,100, which is 6% of 85,000. And when you add them up, you get to 6,000. So you can see somebody earning 100,000 will make a full 6% contribution on their salary eventually. But what you also see is that tier 1 is 900 and tier 2 is 5,100. So the lion's share of that contribution is the tier 2 contribution. And that's important to remember because of things like opting out. Okay. And one last example before I go back to Sandeep. In this example, we take an even higher earner. In this example, somebody's earning 300,000 shillings per month. Okay, in year 1, it's going to look the same as the 100,000 earner because both of them are above the upper earnings limit. So if the pensionable earnings is 18,000, the contribution is 1080, the tier 1 and tier 2 is 360 and 720, and it looks exactly the same. Okay, because anyone earning over above 100,000 over 18,000 will look exactly the same in year 1. Okay, the only people who will contribute less are people earning less than 18,000. But look at the future. If we assume no transition, again, wages of 300, upper earnings limit of 160,000. Therefore, pensionable earnings is 160,000. So this member is still not contributing 6% on their full salary. Okay. If we contribute 6% of 160,000, we get 9,600. We can then go ahead and split the 160 between tier 1 and tier 2. The tier 1 earnings is 15,000 again. Tier 2 earnings is 160 minus the 15,000, which is 145. And then the tier 1 contribution is 6% of 15,000, which is 900. Tier 2 contribution is 6% of the tier 2 earnings. So 6% of 145,000, which is 8,600. It adds up to 9,600. So there's two things I've shown you. One is to show you how to calculate the overall NSSF contribution, which is simply 6% of your pensionable earnings. And the only complicated thing in pensionable earnings is to remember that there's a ceiling on the earnings. And then the second thing we've done is split that contribution into tier 1 and tier 2. And what you can see is that as we increase our contributions because of our salary, a larger and larger component goes into tier 2, while tier 1 is relatively modest. Okay. In this example, the contributions would be 9,600 in total. And obviously that's a big jump from the 200 we currently contribute, but that will take 5 years for us to get to those figures. Sandeep, I think that pretty much covers it. I will stop sharing now.
Super. Thank you.
I'll hand back to you.
Very super. Thank you very much, Adil. Let me share my screen. So, ladies and gentlemen, one of our values as Zamara is simplicity. We also have a calculator that can help you very quickly assess the contributions as well as tier 1 and tier 2. So I will be happy to share that with you. So let me now turn to the final part of our presentation this morning. So one of the things is that this act has implications for all employees. Okay, so and every employer will need to review its existing arrangements. If it has a scheme, if it doesn't have a scheme, if it has a gratuity arrangement, an end of service gratuity, staff on contract terms, all of these things need to be looked at as part of your compliance with the act. And we've got a very simple decision tree that we hope that you will find helpful. Starting with the question, do you have an existing retirement benefit scheme? If yes, then one would expect that the natural course of action for you would be to apply to opt out. And here, some of the things that you would need to check are, firstly, are all your staff covered? What is the definition of earnings? What are the level of contributions? Is your scheme integrated with the NSSF? And this is quite an important point because a lot of schemes have the option where the contributions to the scheme can be offset by what is contributed to the NSSF. And over the next 2 months, as you opt out, it will be helpful to have that provision. And if you don't have it, to have it within your rules. Okay. So if you already have an existing scheme, you may want to consider opting out. And we've already explained the process of opting out and the type of review that you need to do. And we would be very happy to help you go through that process. If you don't have an existing retirement benefit scheme, you then need to say, what do you want to do with the second tier of contributions? You could choose to say that you don't want to opt out, you just send them to the NSSF, in which case you would simply calculate the tier 2 contributions and remit them to NSSF. Or you could choose to say, I wish to opt out. And if you want to opt out, then you need to say, okay, will I opt out by setting up my own scheme? Or will it be, or should I opt out by joining an existing multi-employer umbrella plan? And it might be easier, especially for smaller employers, to choose to go the umbrella fund route. Okay, so if you have a gratuity arrangement currently, you may want to see, is it possible for me to convert my gratuity into a pension arrangement so that I can have contribution, that what I would ordinarily pay for the gratuity, I convert that into regular contributions. So I freeze the gratuity for my prior service and start offering a pension for future service. And again, where there is a union and collective bargaining agreements, you need to see how do you negotiate with the unions. And again, as Zamara, we're very happy, willing, and able to do that for you. So a number of decisions that all employers need to make over the next couple of months as you seek to comply with the legislation. And again, what I want to repeat is that we are very happy as Zamara to take you through all the options, the pros and cons of those, the financial implications of those, and in many ways, especially for those who have retirement schemes and gratuity arrangements, we can help you make those costs broadly neutral and mitigate the impact of this act on you. Okay, and hopefully you can even make this an opportunity to improve your overall employee benefits proposition, as well as how you communicate this to your staff. So, ladies and gentlemen, to come to the end of the presentation part, it's important for every employer to do a full review, assess all the options that are available to you, the impact of these options, the pros and cons, how do you implement, and noting the timelines. And as Zamara, very happy to do that for you. Okay, and in order for us to share with you the information, we have a communique on the Act, which our clients will have received. We also have a set of FAQs, responses to frequently asked questions, which we'd be happy to share with you. So if you want to scan that QR code or reach out to us on nssfhelp@zamara.co.ke, we will send this information to you. Okay, at this stage, I want to open. We have another half an hour or so on this webinar, another 20 minutes or so. I know Adil has been responding to most of the questions, but if you have any others that you want to raise now, please, you can do so. Pithon, I assume that people can ask the question. They can ask on the Q&A. Okay, Adil, maybe you can give us a flavor of the questions.
On the status of casual employees earning commission, seasonal employees, and I've explained that some of these areas require some further clarification. There's a lot of skepticism as well on NSSF that NSSF have not given us much of a track record, and there's a lot of skepticism as to the true benefits that will come out of this act. So that's a pretty loaded question that's being asked, and I think it's a fair question for Kenyans to ask that. So maybe you can talk about that a little bit. And then in terms of tier 1 and tier 2, there's been a lot of questions. I think we've probably answered them comprehensively by now, because I think some of those maybe questions were coming before we did the explanations. But I think maybe that's a good place to start, and I'll keep you posted on what I'm seeing.
Okay, Adil. So seasonal employees, casual employees, as I said, the understanding that we have is that the cabinet secretary will issue a guideline and indicate a daily rate that is payable for casual employees, and this will be done through regulation. But we have asked for it, and we will as soon as we get the clarity, we will give it to you. To the skepticism, and again, I appreciate where that is coming from. There's a history around this. But I guess, there are a few things that many of you may not be aware of, but from the vantage point that I sit, maybe I can share. So I always say that, and maybe people would consider me naive for saying this, but I feel that, you cannot continue to judge an institution by its history. If we keep on dwelling on the past, we will never build a future for ourselves as a country. When it comes to the NSSF, yes, it's had a checkered history, but that is why the legislation as we have it has built in a system of checks and balances. Almost everything that you feel can go wrong, there is a barrier that has been brought in. And also importantly, the increased contributions, not all of them need to go to the NSSF. You always have the option to opt out if you want to. Okay, but a couple of other things that I would mention is that, for example, like the NSSF, just like any other scheme, they appoint fund managers, who invest the money. They have custodians to hold the money. These are providers who are licensed by the Retirement Benefits Authority, the Capital Markets Authority. A lot of us may not be aware, but over 80% of the assets of the NSSF are actually managed by external investment managers. The property assets are looked after by external property managers. So look, there has been a lot of change that has happened. I hope that I hope that I've tried to answer the respond to the skepticism, Adil, that there might be by.
Yeah. A couple questions on the role of RBA versus the NSSF, and what exactly does it mean for the NSSF to be regulated by the RBA? Why was it not being done in the past? And even the opting out, that if RBA is in charge of opting out and they regulate the scheme, is there some kind of conflict there? Somebody's asked if you can put up the slide with the 5-year transition rules. So maybe you can just hang that up as you answer those questions.
Let me try and go to it. Okay, so the 5-year transition is there. So the questions around is why was NSSF not subject to regulation? So I think the point I want to make is that since the year 1998, actually the NSSF has been subject to regulation of the RBA. The 2013 Act, to me, makes it a lot more explicit, brings in more checks and balances that were there than were there before. Is there any conflict between the RBA managing the contracting out as well as being the regulator? I don't believe so. I believe that it is important for the RBA to have the mandate to process contracting out applications and approve them, so that they are not with NSSF. Adil, was there anything else?
I think that's the most of them. Again, I think maybe there's questions about people over 60, and I've explained that there's a bit of a conflict in the Act there, where the definition of employee includes people over 60, but the contributions or the membership of the pension fund is for people under 60. So there's a bit of a vagary there in the Act. So I think maybe just reiterating the steps for contracting out. Maybe what about some people with a provident fund?
Right.
I think basically our view is you can still contract out.
Yeah, absolutely.
And basically,
as long as
two is going to be treated differently wherever it sits, right?
Yeah.
To the rest of the country. Maybe just elaborate on that.
Okay, so look, Adil, do you want me to run through the contracting out process again? Yeah. Okay, all right. Okay, so the contracting out process is where the employer makes a decision to contract out or not. Okay, so once the employer makes a decision to contract out, the employer will need to determine the route it wants to use for contracting out. If it has an existing scheme, the natural route would be through your own scheme. If it participates in an existing umbrella fund, the natural route would be through the existing umbrella fund. If it doesn't have a scheme or doesn't participate in another scheme, then it will need to say, what is the best route for me to contract out? Once that is determined, the employer needs to say, will I contribute at the 6 and 6 at the outset, or will I limit my contributions only to the tier 2 and phase them in as they're being phased in the Act? And that, for a lot of employers, will be an option to ensure that you are transiting those you're doing them over a period of time. So the impact on the cost doesn't hit you immediately. Okay. Again, there's one point relating to gratuities. If you have end of service gratuities, maybe you want to replace them with the pension contributions with the agreement of your employees. And again, as I mentioned earlier, if you have unions and collective bargaining agreements, you need to look at that as well. Okay. Now, once you've made the determination of contracting out and how you wish to do it, you need, as an employer, you need to have a resolution of your board to say that you want to contract out, and this is how you will do it. You need a resolution of the trustees of the existing scheme or your new scheme or the umbrella scheme to say that they are accepting the contracting out and will treat the tier 2 contributions in the manner set out in the Act. You need a resolution of the administrator of your scheme to confirm that they will treat the tier 2 in the manner provided for in the Act and will pay the benefits in that manner. There is a Form C1 to be completed, which is a fairly simple form, which requires a number of details from the employer. All that documentation goes to the RBA, and the RBA will then process your application and revert back to you. Okay. Now, that is the process of contracting out. And again, if you want us to, we are very happy to handhold you throughout this process, prepare these documents for you, and take you through everything that needs to be done. Now, if your existing scheme currently is, say, a provident fund, and you want to say, I want to retain my provident fund, yes, you may, provided that the contributions that you receive as tier 2, you separately mark them within your scheme, and when they are paid out, you pay them in the form of a pension, not as a lump sum. It can complicate the administration a little bit, and that's why it's important to have a competent administrator and to confirm to our clients that as Amara, we can do this very, very well. We can segment those contributions, ring fence them, and have the different benefits based on how the Act requires them to be done very easily. Just to recap, just to reiterate couple of points that I made earlier, that let's say you have a provident fund, and let's say you've accumulated X amount, that X amount can continue to be paid as it was in the past. Anything above a tier 2 can continue to be paid as provided for in your retirement fund rules. Okay. Now there are a couple of questions that have come through to me on WhatsApp, so maybe I can try and respond to them. The question here is: an employer is already running a pension scheme. To contract out, an application has to be made to RBA 2 months prior. It is our understanding that the entity should effect only tier 1 contributions to NSSF, awaiting the certificate from RBA. I would be a little bit cautious here because so see, even as you apply to the RBA and wait for the approval, it is probably best to make those tier 2 contributions. You have until the 9th to remit them. So hopefully if you can get your application approved, if the RBA and the NSSF agree that they can be expedited, then, but otherwise I would suggest you still pay. The Act says that you can then reclaim that money back from the NSSF once you have contracted out. So you can ask for a transfer of those tier 2 contributions back to your scheme once you receive the contracting out certificate. A pension scheme has contributions at 5%. Will the scheme have to amend its trust deed and enhance to 6% to meet NSSF and contracting out requirements? The answer I would say is yes and no. You need to ensure that your contributions are at a minimum not less than the tier 2 contributions. So as you will ultimately need to move to the 6%, but you can, in the first 4 years, as the transition happens, you can pay the minimum that is required. You need to ensure that the 5% is higher than the tier 2 contributions. I hope that's reasonably clear. Okay, I think, Adil, are there any more?
No, I think there's some questions on small workforces with IPPs. I've answered a few of these.
Okay.
Will we need to fill separate C1 forms for each of the providers? So that's an interesting one, because I think as an employer, if you're choosing to opt out, you're probably going to have to sort of limit that, right? You're probably going to have to select one IPP provider.
So I think if you have multiple IPPs, everything becomes a lot complicated because you would have to have multiple contracting outs, and also your payroll system will become very complicated because it'll be quite a nightmare.
IPP and agree with staff to kind of consolidate into one, right?
My sense is that it will be best to have a group IPP for those with smaller workforces. Okay, if there are no further questions, I think we're at 11:15. I believe we can bring this to a close. I can just flash the QR code again in case you want to get in touch with us and want to receive. And Adil is continuing to answer questions. And look, at any time, feel free to reach out through that help email, through the QR code. We will keep sharing information with you. So immediately we will share the communique as well as the FAQs, the calculator as well we can send to you for those who want. So let me bring this webinar to a close by thanking you all. An important piece of legislation. I firmly believe, as a pension practitioner, as somebody who sees what's happening on the pension space, that we cannot be in a country where 85% of our workforce is excluded from pension saving, and even the 15% who are saving are getting to retirement or their old age with grossly insufficient benefits. And as I've said many times before, most of our people are sleepwalking to disaster without even knowing it. And as responsible people, we need to do something about it. We are currently a very young population. Our median age is only 20 years, but in the next 20 years, we will be close to 10 million people above the age of 55. I think we're going to have an exponential crisis if we don't do something about what's going to happen to people when they can no longer work. And if COVID-19 was an example, if it was a struggle to take care of our people during those few weeks of the pandemic or few months, how much harder will it be when people retire and drop off the workforce permanently? How will we take care of them for the 10, 20, 30 years? And I firmly believe that any decent society will want to ensure that its elderly are taken care of. And when somebody, and that those who become vulnerable because of the loss of a breadwinner have something to be able to fall back on. And to me, this is about safeguarding the future of our country, of our society. And I've talked about many of the long-term benefits that come from mobilizing long-term savings. So if I could just mention that if the Act had been implemented in 2014, the total asset base in the country, the pension asset base, currently at 1.6, it would have been around 2.6 trillion. And can you imagine the impact that this would have had? Interest rates would probably be much lower. We would have much lower reliance on donors. And we would have built a better country. And maybe some people might feel this is an idealistic scenario, but that is something we need to think about. I'm being told that we need to close now. I need to check my phone. Second. Yep. So each for Zamara clients, your client service manager will be reaching out to you to ensure whether to help you to comply with the Act. So whatever it is, whether it's looking at your payroll, whether it's the documentation to comply, if you want to make a change to ensure that your contributions are net of the NSSF contributions, we can help you with that. If you wish to opt out, we can help you with the opting out process. We can help you with the evaluating your costs and seeing how you can mitigate them. We can help you with the communication to your employees and to see how best you can put this as part of your employee value proposition. So, ladies and gentlemen, on that note, let me call this webinar to a close. And once again, thank you so much for joining us and your time. I hope we've done justice to it. So thank you again and goodbye. Hmm?
That's better.
Now this is better. No matter what your better is, realize, secure, empower it with Zamara's pensions, medical and insurance solutions. Life is better with Zamara.
That's better.
Now this is better. No matter what your better is, realize, secure, empower it with Zamara's pensions, medical and insurance solutions. Life is better with Zamara.
That's better.
Now this is better. No matter what your better is, realize, secure, empower it with Zamara's pensions, medical and insurance solutions. Life is better with Zamara.
That's better.
Now this is better. No matter what your better is, realize, secure, empower it with Zamara's pensions, medical and insurance solutions. Life is better with Zamara.
That's better.
Now this is better. No matter what your better is, realize, secure, empower it with Zamara's pensions, medical and insurance solutions. Life is better with Zamara.
That's better.
Now this is better. No matter what your better is, realize, secure, empower it with Zamara's pensions, medical and insurance solutions. Life is better with Zamara.
That's better.
Now this is better. No matter what your better is, realize, secure, empower it with Zamara's pensions, medical and insurance solutions. Life is better with Zamara.
That's better.
Currently, my financial priorities, I'm thinking long term. I'm thinking right now I want to use my money to accomplish my dreams, to explore my talents.
When I got employed, my priorities were to get the things I wasn't able to get when I wasn't employed. So yeah, go and try out the fancy restaurants. Yeah, try and dress properly a bit, look like someone who has a job. Those were my priorities. But now they've changed quite a bit for 5 years out of experience and the fact that I became a parent as well. So, yeah.
For now, children is the biggest priority, not myself, not expenditure on myself, yes.
By the time I was at 5 years, I had already made arrangements to acquire my own property. For me, it wasn't that difficult to adjust to a retirement period because I had prepared myself.
You know, those people together would not think, early enough. And they say, for example, putting their own house in order in a good time. They are going through a very hard time in retirement. That's true. I started seeing, for me, say, for example, to make a difference in life, I had to invest. And therefore, I started doing everything so that I could change my life in my 30s.
When I was actually asked to retire, I was not prepared. It is not like today where you are prepared, you are told that in a year, or you are given a job on contract. You know after the contract you will leave.
Retirement is not very far from my mind. So once in a while, I'll obviously take a bit of some time to think about how I'm going to spend my time after I stop working.
Yes, I started thinking about retirement, seriously thinking about it last year when I turned 30. Before that, I was just glad to have it as a benefit that someone was going to put money aside for me and involuntarily cut out mine to put it aside for me. So yeah, I hadn't really thought about it seriously, Percy.
Recently retired from KCB.
I had worked with the corporation for quite a long time, from 1969 to 2000.
I've been out as a pensioner since 1998 to date. I am in the business. I started, say, for example, doing business, that is, matatu business, call it transport, when I was in my 30s. Up to now, I'm still in that business.
3 months into my retirement, it's a beautiful journey. And being beautiful is it's something I had prepared myself, at least the last 10 years prior to my retirement. In terms of incomes, I have my monthly pension, and I had registered my company, Beyond Corporate Communications, which I'm running now. And I can tell you, 2 weeks into my retirement, I had a contract for 3 months. And the same energies, the same commitment. I don't know what it is to retire because I'm waking up. I woke up at 4 in the morning to go on a 6:30 appointment.
Let me tell you, if you are not active during your retirement days, irrespective of how much money you have, you will start vegetating.
With the relationship that I had, even with the bank, I started doing businesses with them. And that actually helped me a lot. I have supplied mailbags to the bank, not only Barclays, but others. And quite a number of other things. I tried quite a number of issues. Today we do a little bit of farming. At the same time, I do some voluntary work. And like the welfare associations, even for the retirees. That's why I started.